The recent Iowa Supreme Court decision on same-sex marriage has unleashed a flood of response from those who disagree with the court's unanimous opinion. Despite the decision, it is anticipated the issue will persist at least through the next election cycle. There have been calls, some from city lawmakers, for local officials to ignore the court's ruling and deny marriage licenses to gay couples on the grounds of personal belief. But the ruling is not the first instance where an Iowa Supreme Court has chosen to expand constitutional protection. Indeed, the state has been well ahead of the historical curve on civil rights.
Even before statehood, Iowa had a legal system. There was a territorial version of the Supreme Court, and like now, that court was where some of Iowa's earliest controversies were settled. Remarkably, this court made decisions that were sometimes more than 100 years ahead of similar national rulings. One of the court's first decisions, in 1839, was to refuse to force a man to return to slavery in order to pay a $550 debt. The court ruled that he did need to pay back the money, but this debt could not form a basis on which any man in this territory can be reduced to slavery. Iowa became a state 7 years later in 1846, and even before the Iowa Constitution was written, the Iowa General Assembly legalized interracial marriage. This legislature also made the radical decision that women could own property in their own names, even if they had a husband. Iowa's Constitution took more than 13 years to write. The first Constitutional Convention was held in 1844, but their writings were not ratified. 2 more conventions were held, and in 1857, the voters and the governor said yes. This Constitution stated clearly that slavery was not allowed in Iowa. In 1868, African American men were given the right to vote in Iowa, and that same year, the Iowa Supreme Court used constitutional arguments to rule that schools segregated by race were inherently unequal and therefore unconstitutional. The United States didn't rule on school desegregation until almost 100 years later. As far as rights for women go, in 1867, Iowa's Supreme Court ruled that women could have custody rights, and in 1869, affirmed the first U.S. female lawyer, Arabella Mansfield. Some of these early rulings from Iowa's Congress and courts seem antiquated to us today, but they were radical in their times. Some have been changed, some reaffirmed. But like the U.S. Constitution, the Iowa Constitution was framed to be a beacon of fairness. All men and women are by nature free and equal, and have certain inalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness.
So clearly, this is not Iowa's first experience with a controversial ruling or the reaction to it. But what can we expect in the coming months? Is social justice the intended role of the Constitution? And how does the Iowa Constitution shape our daily lives? And how will Iowa's decision affect constitutional guarantees in other states? Mark Kende holds the James Madison Chair in Constitutional Law at Drake University, and he's also the director of the Drake Constitutional Law Center. Also on the program tonight is Karen Thalacker. She's an attorney and a lecturer in public law at Wartburg College, also an attorney and an author of a new book called The New Lawyer's Handbook. To the two of you, welcome to the Iowa Journal. Glad to have you for this discussion tonight.
Thank you.
It's going to move along in a quick, and this is a subject that everybody's been talking about. I'm sure your ears have been bent on these. But first, I just want to talk, we just saw how Iowa has really kind of set the standard mark when it comes to cases like this. Is that really the case? Has Iowa been ahead of the curve on decisions like these?
It really has, as you saw from the piece, in terms of issues such as whether a slave is property, whether there can be segregation, the role of women. Iowa has, in fact, been ahead of the curve.
So the question, though, is, has it played out, has the reaction been the same each time there's been one of these historical decisions?
There's always some resistance. There's always some concern and some people who aren't prepared. It varies, though, depending on the issue, and so in that sense, there's some variation. But usually there's some people who don't like it, and there's some people who do.
Well, that's the way it goes. Karen, is that the same assessment you would have from your version, your portion of the state? Has the reaction been the same, the way it played out historically in other times?
Yeah, I would say so, that people have a variety of opinions about the court's ruling. What I hope is that people will actually go to the Supreme Court website and read the ruling and not rely on necessarily people from the media or bloggers to tell you what the ruling said. You can read it for yourself.
We asked a couple of the justices to be on this program, but by their reason, they say their decision stands. Why? What did you glean from, I think it's a 69-page response, what did you glean from it that was some of the things that struck you the most?
First and foremost, that denying same-sex couples the right to the civil institution of marriage violates the Equal Protection Clause of the Iowa Constitution, that you have to give them access to that right. And so much of the disagreement that you hear with the decision is based on religious grounds, and the court does address those at the end of the ruling and say that the county, in this case, who was saying that the law should stand, they didn't even make any religious arguments because that's not appropriate in the society that we live in.
So the things that come out of, or at least the language that comes out of this decision, Mark, is that something that's going to play in other states' discussion about this exact same topic?
Oh, I think very much. It's a very well-reasoned opinion, regardless of whether one agrees or disagrees with it in terms of the result. It's a very well-reasoned, very thoughtful opinion. It focuses predominantly on the equality issue. And in that sense, I think it's going to have some real significance in other states.
What exactly have they gleaned, or what do you think they're going to look at? Are they going to look at the response that's been outside of the court, or are they going to just solely look at that decision?
Well, I think it's going to have the effect of when other courts get this issue, they typically, in other states, look to see what then other states have done. And especially a state like Iowa, which is sort of the heartland of America, to have an opinion like this coming out of a heartland state, written in very powerful and persuasive language, again, regardless of what side you're on, I think it's a really well-crafted opinion. Then the more well-crafted the opinion, the more significant it is in other states.
Karen, do you think the same thing? This will play out differently in other states, or do you think Iowa is going to lead the way?
I think Iowa will lead the way, but I think the impact of the ruling may not be as great as what some people are saying. I think each state has its own culture, has its own way historically of how they reach a consensus. So although I agree with Mark that the decision, whether you agree or disagree, was really beautifully written. It was, as a lawyer, it was fun to read because 10 years from now, 20 years from now, 100 years from now, again, whether you agree or disagree, when you look back on that opinion, you will know who the parties were, what they were arguing, what the law was, and why the court decided the way it did.
Okay, let's move on a little bit of what's next in this decision. We talk about the mechanics of the opposition. There's three that, from my understanding, the ballot, the Constitutional Convention, and an executive order. Karen, I'll let you have the first one here when it comes to ballot. What's it going to take to get this issue to a ballot for Iowans to have their say?
Well, Article 10 of the Iowa Constitution is what covers the process of amending the document. And I think it's safe to say the framers of our Constitution wanted to make it a difficult process. They didn't want it to be a spur-of-the-moment decision. And so the ballot process, it has to go through two separate General Assemblies. Right now, we're in the first year of a General Assembly, which is 09 and 10. So if it gets passed, if an amendment would get passed in this General Assembly, it would then go on to the next General Assembly in 11 and 12. So the earliest possible time that this could come up would be November of 12.
So that's a long way. So we can't even really talk about it. It doesn't count because it's still the assembly, what you're saying, of the folks that have been elected that are serving right now that would come in next January.
Yeah, that's exactly right. And when you look at the way that the Constitution was constructed, the framers wanted to put a firewall, if you will. They wanted the document to remain as it was. Instead of a firewall, I say a flood wall, because Iowans are familiar with that.
Very familiar.
That's right. That they want to make sure that the little ripples in public opinion, maybe the little rising water from the passing storm, that doesn't get over your flood wall. But if you've got rising water for a long period of time, you may get a constitutional amendment, but it's going to be hard.
And that's exactly, as you said, the Constitution was designed that way. What about the Constitutional Convention? What's that entail?
It basically entails the public, in 2010, getting a chance to vote on whether to have a constitutional convention. The idea actually goes back to Thomas Jefferson, who in some of his writings said countries should every 20 years consider whether to have a new constitution or not. And Iowans recently decided to give the populace a chance every 10 years to make that decision. So if they were to vote in favor of that, then the General Assembly would have to devise some rules for going forward with the Constitutional Convention. But the trick is, that doesn't have to be limited to just the gay marriage issue. So that's what makes it a complicated question.
It could be several things. Now, you mentioned a couple things I want to break down, and one is just how do you appoint who goes to a constitutional convention? I mean, we heard the term in the last general election about superdelegates. I mean, is that kind of the way it is set up? Are there people appointed on both parties, or how do you make that convention up?
My reading of the Constitution is that it's going to be up to the General Assembly to decide that. Now, I know some other states in the country that have had this opportunity. So Montana has a relatively modern constitution, 1970s, unlike ours, which goes back to 1857. When they decided to set up a constitutional convention, what they decided to do was to not allow any current sitting members of the legislature be the delegates.
Wow.
And that was their way of preventing the sort of political elites from being in control, and instead to leave it to the populace. So that's certainly one option, although one suspects there's some temptation always for the politicians to have a role. So we don't know how that will play out.
Well, there's plenty of former politicians who would probably sit that have experience who are no longer in office. The people, but how does that get started? I mean, are we coming up to, you said 2010 is when the next time we can even talk about this?
Right, so it's supposed to be pretty much on the ballot automatically, and then there's a vote on that. And, you know, typically the people of Iowa have voted against it. You know, there could be a real movement by folks who oppose this proposal, this ruling from the court, to put this on the ballot.
So who even puts it on the ballot, I guess I should have asked first?
Well, the first decision will be whether to have a convention.
Okay.
And then the delegates of the General Assembly would decide what the rules are for that convention. And presumably one of the rules would be to invite proposals. And one of the proposals could be on gay marriage, but it also could be on a whole host of other things.
So the scope is wide.
Right, and it will be on the ballot regardless of whether this decision came about or not. It was scheduled to be on. It's every 10 years under the Iowa Constitution. That opportunity is given to the citizens. I think it's interesting, and it's more of a political topic necessarily than a legal one, about the politicians not talking a lot about having a constitutional convention, because I think they know there's just no precedent for it here, and it would be difficult to set up, and you do open up the entire Constitution to amendment. And again, any amendment that was passed would still have to go on a ballot, and the citizens of Iowa would have to approve it. But yet I think people would be a little bit nervous about the whole Constitution being out there for people to change.
Because you're saying it could be something ridiculous as everybody must use blue pens.
Exactly.
And they can no longer use green pens or red pens or something.
That's exactly right.
Okay. Let's talk about the executive order. That's the third one in this that's an option. There's a candidate for governor on the Republican side who said the very first thing he would do would be to sign an executive order. What type of weight would that hold?
It would have no weight. It would have no legal impact whatsoever on the decision that the Iowa Supreme Court made. Zero.
So, same answer to that question?
Yeah, she's gotten it exactly right. It's basically not considered to be as significant as a constitutional ruling. The Constitution trumps an executive order.
So the executive order, it would basically just be a piece of paper that wouldn't hold any legal weight.
Right. The most it could do is it might create some complications, and maybe a court would have to get involved for a moment and say, this has no weight. And that's basically where you'd go.
Well, as I say, where would it go next? You're saying it would go to which court level would it go to? Would it go right back to the Supreme Court, or would it have to start back in the district court level?
Well, I think if an executive order got issued, it would first depend on whether anyone followed it, knowing that it's really not law. If anyone followed it, presumably those people who were aggrieved by that would then go to court and say, this has no weight, please announce that again.
You've just led us right into the next thing. You talk about following it or not. Civil disobedience is is almost the buzzword of the week, where we're hearing there's been a ruling from the Attorney General that says, no, you have to follow this rule. And then there's a senator from North Iowa who's saying, you know what, if you don't want to, you don't have to. What do you make of this?
I think they're supposed to follow the rule. It's a constitutional decision. They're supposed to follow the law. They're sworn, and they take an oath to uphold the law. They have opportunities through the amendment process that we've talked about to try to change things. They might try to do some legislation involving religious conscience issues, but in the absence of that, it's a court ruling. That's their job, and they're supposed to follow it.
Karen, what happens if they don't, though?
Well, somebody's going to get sued.
You think that's what they're going for?
Yeah, and you know what, people, it's kind of a misunderstanding about individual rights. You know, you have to observe someone's individual rights, even when it's not popular. That under our Constitution, individual rights are important. And people do not, if they do choose to ignore the Supreme Court order, I am confident there will be consequences for that.
But hasn't civil disobedience kind of gotten us on the road to fixing civil rights in the past, though? Hasn't civil disobedience done a part of making headway for what we're talking about today?
Well, I think there's no question that people, I'm not sure if civil disobedience would be the best choice here, but if there is an uprising, if there are a lot of people who are upset, if there are protests, then maybe that's going to have some impact politically. But it won't have an impact legally. It would have to play out through this political amendment process or having a convention.
It sounded like you wanted to say, I'm sorry.
No.
Okay, all right, then I'll move on. I want to talk about social justice and the intended role of the Constitution. Is that what the role of the Constitution's been, is what we call the social justice?
Well, it's one of the roles. You know, a Constitution also sets forth the broad framework of your government. How is it set up? But it also does set forth for everyone to see what the core values of your country are, or your state are in this situation. And I point people to the United States Constitution, where the Bill of Rights was actually, you know, the first 10 amendments to the Constitution. It wasn't part of the original document. In the Iowa Constitution, your Bill of Rights is Article 1. It is front and center in the beginning of that document. That's how important it was to the people who were writing that document.
Very good. And I'll let you answer the same one about social justice.
You know, I think it's exactly what Karen said. It's a combination of an embodiment of the values of Iowans, and the Bill of Rights is maybe the place where those values are most clearly embodied. But I don't want to forget, it is also a structural document, and it sets up the structure of government. And so in that sense, it's crucial in that respect. That may seem less colorful as the Bill of Rights provisions, but really the whole governmental process depends on the way it's structured.
Well, and we did rewrite the structure a little bit. Iowa comes after the country, so I mean, did we do it right? Did we do it better?
I don't know if we did it better. We certainly did it in a way that is not completely different from the way the country did. There's an interesting part of our Constitution, though, which explicitly mentions the phrase separation of powers, which is not explicitly mentioned in the U.S. Constitution, although courts have said that is a part of it. So maybe we did some things to make them more explicit. But the basic structure, a legislative branch, a judicial branch, an executive branch, we followed with our state.
And when you're talking about individual liberties, you know, the majority is going to be just fine. They're going to be okay taking care of themselves. One of the things that a Constitution does is watch out for the rights of the individuals, the people who are in the minority. Mm-hmm. So when I hear people say it's majority rule, a majority of Iowans are against this, I think to myself, well, you know, you don't put individual rights up to a popular vote, because most times they would lose. Sometimes, again, individual rights are not popular, but they are important.
Very good. I want to move to the last question here of the night. Is you both spend time in the classroom instructing pre-law or law students, and you get to interact that way. In 5 years, when those, maybe they're sophomores, juniors, seniors, when they're practicing attorneys, or any of us in 5 years, what is going to be made of what we're talking about right now and what came out of the Supreme Court?
You know, I think a lot will depend on how this process works, whether there is a constitutional amendment or not. Obviously, that's significant. But I think in 5 years, regardless of what happens there, this will be a decision that people look back on and say, this is one of Iowa's most significant decisions, potentially one of its most influential. And as I said earlier, again, regardless of your position on it, one thing I hope people do is what Karen suggested, read the opinion. Mm-hmm. And it's a well-crafted opinion, whether you agree or not. And so that should hopefully mean it has a legacy as something people read and learn about, particularly being part of Iowa.
What are they going to learn, though, if they read that opinion?
They're going to learn some things that maybe some people don't agree with, but they're certainly going to learn that in Iowa, equality, you know, one of these basic rights, that in particular minorities are the ones who need equality because the majority is usually doing fine, is very important in the Iowa tradition.
All right, Karen, what are you going to take from this in 5 years? Look in your crystal ball. What do you see 5 years later from all of this discussion?
I think people will still be debating this issue in 5 years. Just like Iowa was so ahead of our time with some of those early civil rights cases in the mid-1800s. It took until the mid-1900s for the rest of the country to catch up with us. And so I think this is an ongoing discussion, and we in Iowa are going to have a front row seat for it.
Are you excited about that?
I am. I'm excited. Any time that we can get people talking about the importance of individual rights, that's a pretty good day.
Have you been stopped in the last couple of weeks to talk about what's happened? Just people want to know your opinion on things?
Yes, and I would say whether it's the grocery store or my church, people want to know about it. People are talking about it. That's why go to the Iowa Supreme Court website and read the opinion.
All right, that's Karen Thalacker. She's from Waverly, Iowa. She's a lecturer in public law at Wartburg College, also an attorney. Her new book coming out is The New Lawyer's Handbook, and Mark Kende is in Des Moines. He's a professor of law, the James Madison Chair in Constitutional Law at the Drake Constitutional Law Center. Thank you very much, both of you, for coming in tonight, and that's going to do it for this edition of the Iowa Journal.